All right. Today we're going to go over the residential listing agreement. So, congratulations, you got the listing. Now it's time to fill out the RLA and get to work and selling the home. So, let's go over this disclosure here known as the RLA. When you click in your zip forms, the residential listing agreement, it will populate up. Keep in mind, there are 5 additional disclosures that accompany the RLA. There's going to be 3 disclosures that are before the RLA, and then there's going to be 2 after the actual RLA. So there's the AD. You'll see when you populate it here, you're going to see here Form AD, which is known as the Disclosure Regarding Real Estate Agency. The second form is going to be the PRBS. The third form is going to be the wire fraud advisory. Then it's going to go into your residential listing agreement known as the RLA. After the RLA, there's going to be 2 additional forms. It's going to be the seller advisory and also the CCPA, the California Consumer Privacy Act advisory. So in total, there's 6 disclosures combined in that accompany the RLA. So let's get right to it. You all should be pretty familiar with this Form AD, which it discloses the relationships in the transaction here and what their duties are. Keep in mind the AD is not a contractually binding agreement with you and the seller and or buyer where it could go before a judge and then they give you representation. It's just to disclose who is actually involved in the transaction and also authorizing you to speak on behalf and talk real estate business. So as we get to it, you'll see that this box here, this will really never be checked. This is only for leases or things like that over 1 year. So you will never really check that box here. The rest is just the seller's agent duties, buyer agent duties, agent representing both seller and buyer, known as dual agency. So here on the first page of one of 2, whether it's in this case, it will be the seller. You're going to check the seller and put it here. Now, when you are filling out the RLA, a couple things to be very mindful of is you need to check the title. You need to make sure who is the actual seller. Is there 1 seller? Is there 2 sellers? Is it in a corporation? Is it in a trust? You need to know these things. So you will fill out the actual seller here, and this also requires the agent's signature as well, page 1 of the AD. Page 2 is just pretty much different legal terms here. It's really, we're not going to go through all of them too. It just talks about how it ties it into civil law and what your representations are. The next form is known as the PRBS, Possible Representation of More Than One Buyer or Seller, Disclosure and Consent. So in a transaction, you might have multiple buyers make an offer on this property, or you may have multiple sellers that have very similar, if not the identical property that you are trying to sell, and you just have to disclose that to your seller. Okay. So this gives you authorization to represent as a dual agency, or if there's multiple buyers or multiple sellers. This form will also require the seller's signature, the buyer's signature, and both agents involved here and their signature as well. These forms, the Form AD, the PRBS, and the WFA are also duplicated on the residential purchase agreement, the RPA, but it just goes to show you how imperative these forms are to accompany either the RLA or the RPA. It's good to get it done if you are taking a listing upfront here, so you just make sure you have this on file. Next will be the RFA, the Wire Fraud and Electronic Funds Transfer Advisory. This is very important here because wire fraud is on the rise. So you just need to tell that your seller, hey, look, wire fraud's on the rise. If you ever get any wire instructions, please cross-reference them with me first before sending any money, because this is a very real and it's very prevalent to the real estate industry. A lot of criminals are going in, hacking escrow officers' emails and posing as an escrow officer to try to get you to wire funds to them. So just be very mindful of how important the wire fraud is. And this will require buyer and seller signature. Does not require agent signature on it. Now, as we get down right to business here, the residential listing agreement, the first thing you're going to want to do is put in the date prepared. Now, this date of preparation can be different from the date you're actually listing the property. Okay. So when we're going through this here, the first part, you're going to want to have this filled out, and the name needs to be the seller. Okay. And we need to know if it's one seller, two seller. I've seen as much as 5 or 6 sellers on a property, or again, if it's in a trust or an LLC. If it's in a trust or LLC, that is the actual title holder and an actual owner. So then you would need to put the name of the LLC or name of the trust as the seller. And at that point, you're going to accompany what's known as an RCSD-S form. And we'll get into that a little bit later, but basically it's assigning a person that is authorized to sign on behalf of either the LLC or the trust. And when it comes down to probate as well, that could be another one. If you are selling through probate, you need to know one of two things. If it's the executor of the estate, then you would put that, or the administrator of the estate. Now, what's the difference? An executor is usually determined in the will, and an administrator is usually determined when it goes through probate and a judge has to approve it and give them the rights. So if you guys do get a probate, just go ahead and talk to me about it, and we can, get down to it a little bit further. So again, seller, make sure it's very important that you have all sellers on there. If there's a husband and wife and it's just husband on the RLA and wife is on title, this is not a binding contract because not all parties have signed. Very similar to the RPA as well. The next, you'll put the broker. So the next line here would be Western Pioneer Properties. Very simple. And you need to have a beginning date and an ending date right here. Okay, you must have both for it to be legally binding. So the beginning date can be different than the date prepared. And oftentimes it is, because you don't know when you're actually going to take the listing, get it live, and get it on the MLS and start marketing and advertising it. So again, beginning date of the listing, ending date of the listing must be filled out. Next is going to be the property. So I just put some dots here just so I could get the form, but let's say it's 1234 East Main Street, Fresno, California, 93720. Okay. So you're going to put the address here, situated in the city here, the county. In my example, it would be Fresno, and then the zip code. It's always good to put in the APN number. This is not mandatory, but it's good to just have the contract complete. Oftentimes when you're dealing with land, you would put the APN number there. Now, keep in mind, land has a separate residential listing agreement and has a separate purchase agreement as well. But it's always good to put the parcel number here. If you don't know where to find the parcel number, you could typically find it on the MLS listing, or you could just look up the tax records and you'll be able to find it there. If the property is a manufactured mobile home, you will want to check this box here. If the property is being sold a part of probate, conservatorship, or guardianship, you will check this box here. And again, we just discussed that a little bit on probate. Number 2, listing price and terms. You will need to write out the exact price. Let's say it's $300,000. You will need to write that out, and then you will put the numerical 300,000 right here. For those of you who are old enough and remember writing checks, that's exactly how you would have to do it. You would have to write out the amount, and then in the little box, you would put the numerical dollar amount. If there's any special terms, be here, you can put it here, listing terms, okay? An example of listing term might be, hey, sellers willing to give me a $500 bonus if I could get more than X amount for my home. Or any other terms that you could think of that might pertain to the transaction, you're going to go ahead and be able to write it in right here. Now, number 3, the compensation to the broker. the most important part of this thing. So you make sure if you are putting in your work and investing in marketing materials and professional photography, that you obviously get paid. Okay. So look what they put here in bold. Notice the amount or rate of real estate commissions is not fixed by law. They are set by each broker individually and may be negotiated between seller and broker. Parentheses, real estate commissions include all compensation and fees to broker. Now, the reason why they put this in is because a lot of real estate agents were going around saying, hey, it's law that it is 6%. They were using that as a sales pitch. They were saying, it's a standard California law that it is 6%, which it is not. You could say something to the fact that typical real estate commissions are 6%, or standard of what we're seeing is 6%, but you cannot state that it is law because it is not. Okay. So just make sure that we're clear on that. 3A, this is where you're going to put the percentage of what it is. If it's a 6% commission or a 5% commission being split 2.5, we'll get into that a little bit further. Anything less than a 5%, you have to get company permission here at Western Pioneer Properties to discount that. Okay. So A, seller agrees to pay the broker as compensation for services irrespective of agency relationship. Either, and you're going to want to put the percentage amount here. Make sure you check this box. Very common that I see this box unchecked. You need to check this box and put the percentage here. And hopefully it is 6%. Or maybe 5%. So of the listing price, or if you want to do a flat amount, you can check this box here and just put the flat dollar amount that they are going to pay you, seller to broker. And you could include anything in addition over here. Okay. 98% of the times, it's just going to be this box checked and the percentage goes 6%. Okay. And we'll get down to it a little bit further. Buyer's broker, okay, you'll check here and typically we'll see 3% here. So when you're explaining that to your seller, hey, 6% is total, but 3% is going to be given to the buyer. Unless I represent both sides, then we could talk about it further. Unless you could go and get your 6%, and that would be awesome. 3.1 here, if during the listing period or any extension, broker, cooperating broker, seller, or any other person procures a ready and willing, able buyer whose offer to purchase the property of any price and terms is accepted by seller, provided the buyer completes the transaction or is prevented from doing so by seller, broker is entitled to compensation whether any escrow resulting from such offer closes during or after the expiration of the listing period or any extension. When we take a listing, we are taking what's called an exclusive right to sell. We don't take open listings. We don't take any other listings but exclusive right to sell, and that's what we are doing here. But this is very important too here. On 3.2, if within blank calendar days after the end of the listing period or any extension, after any cancellation of this agreement, unless otherwise agreed, seller enters into a contract to sell, convey, lease, or otherwise transfer the property to anyone, prospective buyer, or persons related entity who physically entered and was shown the property, broker submitted a seller a signed and written to acquire a lease, exchange, or obtain an option of the property, and seller or any extension or cancellation, broker has given seller written notice of the names of the such prospective buyer. So that's a long clause, but let me break that down for you. So basically, if you put in a date here, and there are some brokerages that actually do, they'll put, a 6-month date here or a 3-month date in here, which isn't a bad idea. So basically what this is stating is after the listing is canceled or after the listing expires, if it did not sell and a buyer came in and wrote an offer and got into contract here, you would have a right to the commission if it's within X amount of calendar days. However, after your listing has expired or you didn't sell it or it got canceled, you need to give them a written list of the buyers that went and saw the home. Now, this can be pretty tough because you don't actually really know who the buyers are that actually view the home. because it's obviously the buyer's agent who goes in there. When you look at the lockbox of who's shown the property, it obviously won't say the buyer's name. But if you can prove that, you are entitled to a commission. This is more prevalent in higher end homes, luxury real estate, when you're setting up appointments. Typically, the seller is going to know what buyers are going to see the home in luxury end homes. Very popular in, La Jolla or Beverly Hills or places like that. Then you could give them a list of the buyers who actually saw the home. Okay, so that's one thing as well. Or number 3 here, if without broker's prior written consent, the property is withdrawn from the sale, conveyed, leased, rented, otherwise transferred, or made unmarketable by a voluntary act of the seller during the listing period or any extension. Okay, so you have a right to the commission or some sort of commission if the seller cancels early on you, because you're invested in this. You're invested with your time. You're invested with your marketing materials. You probably paid for a professional photographer and or videographer. You've, spent money advertising on social media. So those are things that the seller needs to be aware of. Hey, if we're signing this legally binding RLA contract, and if I pull out, there could be some compensation owed to me as the listing agent. Okay, so that kind of is what we're dealing with on 3 here. In addition, seller agrees to pay broker. This is left blank. More times than not, it is left blank. What could be an example of something that goes there? Well, let's say the TC fee. The TC fee, if you want to try to pass that along to be paid for by the seller, you can put it here, and you will have to state the dollar amount. Seller agrees to pay broker the transaction coordination fee of $350 or whatever it may be. Okay. We touched on 3D here of seller has been advised of the broker's policy regarding cooperation with and the amount of compensation offered to other brokers. And this is where we're going to offer it. Make sure, again, you check this box and you state how much that you're going to offer the buyer's agent. The buyer's broker. This also needs to be reflected on the MLS, or if it's in a dollar amount, you'll check this box and state the exact dollar amount for the compensation to the buyer's broker. 2, broker is authorized to cooperate with and compensate brokers operating outside the MLS as per broker's policy. So basically stating a commission still will be paid even if they're not a member of the local Fresno MLS. Okay. Let's move it along here. So there's a couple clauses over here that very rarely get filled out here. So we could go through them really quickly. Seller represents as seller has not previously entered into a listing agreement with another broker regarding the property unless specified as follows. So you would put that in there. F2, seller warrants that the seller has no obligation to pay compensation to any other broker regarding the property unless the property is transferred to any of the following individuals or entities. So that might be a one-off situation, but if they're, if somehow they're requesting, hey, if I sell it to this person, then I may not be paying a commission. So that is something to be mindful for, and typically we want to leave that blank there. Okay. F3, if the property is sold to anyone listed above during the time seller is obligated to pay the compensation, another broker is not entitled to compensation under this agreement. And 2, broker is not obligated to represent seller in such transaction. So just be very careful of those there. And you will need seller initial here on page 1 of 5 of the RLA. Okay. Moving to 2 of 5 on the RLA. When you put in the address up top of page 1 of the RLA and the date prepared, it's going to automatically populate here and over here. Okay, so just keep that in mind. Number 4 here is what items are excluded or included in the sale. Unless otherwise specified in a real estate purchase agreement, all fixtures and fittings are attached to the property are included, and personal property items are excluded from the purchase price. So if there's a fixture and you're excluding it, let's say it's a nice chandelier, go ahead and mark it here. If it's a fixture that's affixed to the property, you'll want to make sure you specify it again right here. Additional items include, and you can include it here, hey, maybe a tough shed or some personal property there, or let's say a countertop microwave. You might want to put that in there if it's part of the sale, because a countertop microwave is personal property. Okay, so keep that in mind there. We're going to go to B here, items that are leased or not owned. We want to know if the following items are leased or not owned by seller: solar power system, alarm system, propane tank, water softener, or other. So that's what we'll mark here. Most commonly is probably solar and alarm system. So just make sure that we know that. And moreover, on 4B2 here, the liened items. Is there a lien on the house? Okay. The following items have been financed and a lien has been placed on the properties to secure payment. Oftentimes we see the solar, windows or doors, heating, ventilation, air conditioning. There is a space right here for other where you might put a hero program, one of those governmental programs that bill you through property taxes. That can go here as well. So moving right along, multiple listing service. What is the MLS? This just states what the MLS is. B, what information is provided to the MLS. And here on 5C, you will need to fill out which participant and subscriber to MLS that you are part of. In most cases here, we're going to go ahead and put Fresno, but it might be Kings, or it might be Tulare County, or if it's multiple, you'll want to put it in there as well. And if you are not part of that MLS, or that's not your primary MLS, then you will check this box here. Okay. Now, in depth about the MLS as the exposures to buyers, when you are on the MLS, it does become public record. People see the pictures, things like that. So we just want to be very, very mindful that once we start marketing the property, it will get out there to the public. And seller needs an initial here. And this says broker agent's initial. This will be the agent's initial. You don't need myself or any of the fellow brokers to sign off on this. You as the agent will initial here. Sellers will initial there as well. And again, seller will initial at the bottom of page 2 here. Number 7, public marketing of the property. So we do want to just let them know that, hey, it will be syndicated to other websites that will be marketing the property. But that is something that, comes with the territory. MLS, you're not going to get the exposure. You're not going to get the top dollar. You're not going to get the amount of showings. So it's imperative you do get this on MLS. 7C, coming soon status, impact on marketing. Seller is advised to discuss with broker the meaning of coming soon, as that term applies to the MLS in which the property will be listed, and how any coming soon statuses will impact when and how the listing will be viewed to the public via MLS. Seller does or check the box does not authorize broker to utilize coming soon status, if any. Okay, remember, when you are doing a coming soon status like that, you cannot show the property. Coming soon, you are not allowed to show that property, and just be very mindful of that there. Okay, moving along, again, property address will populate over here on page 3. There's a place where you can put seller instructs broker. Seller instructs broker to market the property to the public and start marketing on the beginning date of this agreement. Okay, that it will automatically, whatever you stated on page 1, the beginning of the listing, that will take precedence. Or if you check this box and put in a specific date, then that will trump the date that you previously had on page 1. We don't want this box checked here, but if in case you do go over some of the terms that don't want it marketed to the public on the MLS or any other items, then you would check this box here. But if we're not going to put it on the MLS and you are taking a listing, Western Pioneer Properties needs to approve that. Okay, we need to approve that listing. All right, moving right along here, there's not too much that we need to check. Clear cooperation policy does not apply. We're going to go ahead and leave that blank. Again, they really hammer down on the MLS data on the internet, because in the past it's became a confidentiality thing where, people are complaining, hey, my daughter's room is being shown and syndicated on 86 different platforms, and we have our pictures on the wall with family, stuff like that. So that's exactly why we have all of these legal disclaimers here regarding that. Okay. Again, this would be an opt-out feature if certain internet features as provided by CAR or SELI or local equivalent form. Okay. Just again, little bit of legal disclaimers here. Seller representation. Seller represents that unless otherwise specified in writing, seller is unaware of any notice of default recorded against a property, any delinquency amounts under any loan secured by or other obligation affecting the property, any bankruptcy, insolvency, or similar proceedings affecting the property, any litigation, arbitration, administrative action, governmental investigation, or other pending or threatening action that may affect the property or seller's ability to transfer it. So seller does need to be honest with us and let us know if possibly they may be going through a divorce and there's some sort of litigation going on with that. They definitely need to disclose that to us as seller, as listing agents, so that way we can pass that along. Number 10, broker and seller duties. Okay, these are pretty standard, kind of reiterates what's on the AD of, what our duties are as a listing brokerage and how we're going to handle it. Investigation and report. Seller agrees within 5 or beginning date of the agreement to pay for the following pre-sale reports, maybe a structural pest control or general property inspection, homeowner association document. So if they have already ordered those things and you do have on hand, then you would check those box, or other possible home inspection, something like that. Okay. Moving right along, let's go to number 11, deposit. Broker is authorized to accept and hold seller's behalf of deposits to be applied towards the purchase price. This won't apply to Western Pioneer Properties. We do not accept deposits. Deposits go strictly to escrow and title. Okay. Agency relationships, disclosure. The seller acknowledges receipt of, this is checked, disclosure regarding real estate agency, CAR Form AD. So it's automatically checked, automatically populated as the first form when you click on the RLA, as we already spoke about. Seller representations. Broker shall represent seller in any resulting transaction except as specified in paragraph 3F. Also talking about possible dual agency with the buyer, depending on the circumstances. It may be necessary or appropriate for broker to agent on both sides. Okay, so we're moving along to page 4. Here's page 3. Make sure that they initial on page 3. And again, talks about the dual agency, the confirmation, also potentially competing sellers and buyer. Okay, again, this reflects the PRBS we spoke about. So this is just another clause that's reiterating security, insurance, showings, audio, and video. Broker is not responsible for the loss or damage to personal or real property or person, whether attributable to use a lockbox, key safe, a showing of the property, or otherwise. So we are not responsible for any damages or theft on the property, and we are stating that. Okay. Also, if they do have stuff that's very important, make sure that you tell them during this time. You're going to want to make sure you lock that up in a safe or a nice hidden spot, or take it off the property if it's or has a lot of value to it. Next, number 14, photographs and internet advertising. Kind of talks about, again, pictures are going to be out there. Seller usually agrees to this, but if not, then this box would be checked here. And again, if they don't agree to being on photography to be on the MLS, then that box needs to be checked, but then we have to approve that, because then it means it's not on the MLS. Okay. 14B, seller acknowledges that prospective buyers and or other persons coming onto the property may take photographs, videos, or other images of the property. Seller understands that the broker does not have the ability to control or block the taking and use of images by such persons. If checked here, seller instructs broker to publish in the MLS that taking images is limited to those persons preparing appraisal or inspection reports. Seller acknowledges that unauthorized persons may take images who do not have access to or have not read any limiting instruction in the MLS, or who takes images regardless of any limiting instruction of the MLS. Okay, so just kind of some legal jargon here regarding the person taking the photography there. So again, this is just indemnifying us from being overly intrusive. A key safe lockbox, it's basically stating that, you know, there will be other brokers that will have access to the key to get on the property with full permission. If they do not want a lockbox, that's where you'll check this here on number 15. So also the sign, the seller does, or if checked, does not authorize broker to install for sale sign on the property. So again, if any of these are checked, you need to bring it to our attention because we want full exposure. We want to make sure when we market the property, it's done correctly and we give it as much exposure and showings as possible. So we don't want these boxes checked unless sometimes they don't want a sign in their house because, hey, maybe they don't want the neighbors to know that they're moving or something like that. Then we would just go ahead and check this box here. Okay. Equal housing opportunity. That's pretty straightforward. Just talks about we don't, accept or market or negotiate based upon race, color, religion, anything of that nature. Number 18, attorney fees. So if there's if a dispute arises, basically this clause states that we're not going to pay for those fees. Additional terms, if it's a bank-owned property, then you would have to check this box here, and then the REO advisory would pull through. Short sale, if it's a short sale, then it'd pull through here. Again, if it's in a trust, we're going to want to check this box here, and the TA will pull through. And then the last box, seller intends to include a contingency to purchase a replacement property as part of any resulting transaction. 19, this one sometimes can be checked, especially in the market that we're in. If the seller needs to sell this home, it's contingent upon their next purchase, then you would check this box here, and then we'd fill out that pulls through. Again, page 4, you're going to see the initial here. As we move on to the last page of the RLA, this thing, management approval. This more has to do with us, successors and assigns. This agreement shall be binding upon the sellers and sellers' successors and assigns. This has to do with, let's say if it's in a trust, who's the successor trustee? Okay, then we would know that through the RCSD and get to it. A dispute resolution, you have the option of mediation. Okay, so we agree that it's going to be disputed through mediation at that point. Then it could be taken into small claims court. Unless it's over $10,000, then it becomes civil court. Okay. We also talk about arbitration advisory. Now, when it comes down to the dispute between seller and buyer, that is determined on the arbitration and mediation clause in the actual purchase agreement. Okay. Nothing legal jargon. You don't need to read every numerical number to your seller, but just go through it enough where you can explain these in just 1 or 2 sentences and then move on from it. Okay. The RCSD form we talked about, the representative capacity signature disclosure. That's what it stands for, -S. Again, that will tell us the individual that's authorized to sign on behalf of the corporation or on behalf of the trust, something like that. If that's the case, this box will check and the RCSD will populate into our zip forms. All right, we made it of the RLA. This is where the seller is going to have a name and we're going to have them sign their address and fill it out as much as possible, and date as well. So seller, have them sign. If there's more than one, this box here, the additional signature addendum, the ASA will get attached. So if there's more than one signature, we'll need it there. And this is where the real estate broker firm, Western Pioneer Properties here. Okay. You'll put by, this is where the agent, and sign. Make sure all of this is filled out. DRE license of Western Pioneer Properties, our office address. Here will be you, your telephone number, your email, your DRE license, and the date. If there's two brokers that are cooperating from two different companies on a listing, that's where this box would be checked here. And then we would have to fill out an ABA form, which we'll have a training on further down the line. And that's it. Once you get the ink on this, you're ready to go to sell the home. But let's move on. SA, the seller advisory, and also the CCPA. So seller advisory is very simple. And again, once you fill out the property address on page 1, it's going to populate the address over on this form as well. It just talks about the general duties of a seller, which also it highlights, the TDS, the SBQ, and, you need to disclose any material facts about the home. Are you aware of anything? Is it an airport noise zone? Is it in a flood zone? Is it in a fire zone? Something like that. As a seller, death or other disclosures. If someone had died on the property within 3 years, you must disclose that. Okay. Condos and other common interest subdivisions here just talks about if you are in a condo. Contract terms and legal requirements, pretty straightforward. So you're going to have the seller's initial on page 1 here of the SA. Withholding taxes under federal and California law, you could be responsible to pay maybe a capital gain, especially if it's a investment property. Okay. So there's a form known as a 593C form that escrow will have them fill out to determine that, how much they're going to pay. You can't give legal advice. So what you have to do is just, defer them to their tax. And again, just advisor needs to close. Seller signs here, prints the name, and we'll do it here as well. And on the SA, the real estate firm needs to be put just like the RLA, page 5. And we put the agent, DRE number, date, everything else filled out and signed here. Okay. Now, the very last form to this complete RLA is the CCPA, California Consumer Privacy Act Advisory. Just talks about that, your privacy can be compromised if we do market this out to the public. Again, they hammer down on it on the RLA, they hammer down on it on the AD, and now they're just just to make sure that there's no mistakes. Third-party places or internet websites will get a hold of this once it's on the internet, so they just need to be aware of it. We'll let them know that, hey, here at Western Pioneer Properties, we do not share any of that information, but the information can be out there on the internet, and it a bit of your privacy. But we're on a day and age if someone wants to find out things, they can find that on the internet as well. And lastly, the sellers will sign here and date. And that is it. That is the RLA form. That's how you fill out the residential listing agreement. Again, it has a total of 5 additional disclosures from the RLA. That order again, the AD, the PRBS, the WFA, then it goes to your RLA, then it has the seller advisory, and then the CCPA. Once those are completely filled out, signed by all parties, including yourself as the agent, and it's fully executed, initialed on every page, you are ready to turn this in and set up your photography and get marketing to this and sell the home. So thanks for sticking with me through this RLA training. Hopefully this was helpful. If you have any other additional questions, you can always reach out to myself or maybe your team lead, and we're happy to answer any of those questions. But congratulations on your listing, and we'll see you on the next video.